The recent protests across our television screens protesting the death of George Floyd and so many others have thrust the conversation of police brutality back into the spotlight. But what is police brutality and what happens in the court of law? What are the legal lines in this conversation? Defense attorney Gavin Holihan joins us tonight to discuss those questions and more. That's all coming up right here, right now. I'm Sam Chen. This is Face the Issues. Good evening and welcome to Face the Issues. I'm your host, Sam Chen. You don't have to look far to see the protests that have been played across our screens across the nation in the weeks after the death of George Floyd in Minnesota. But in the conversation of police brutality, in the conversation of our legal and justice system, there are a lot of questions that need to be answered. And there's no one better to answer those questions than defense attorney Gavin Holihan, who joins us tonight. Attorney Holihan, welcome back to the program. Thank you so much for your time.
Oh, my pleasure. Thank you for having me on, Sam.
It's always a pleasure to have you, and it's certainly, different than before. I wish you were here in studio with us, but given the current situation, it is what it is. Attorney Holihan, let me get right to this. Obviously, police brutality is the conversation of the moment right now. And it defined it's a civil rights violation where officers of the law exercise undue or excessive force against a subject. In your experience, you are a defense attorney, you've been a prosecutor. In your experience, what constitutes police brutality, and where is that line between a justified use of force and police brutality?
Well, that's a great question, because the line is almost an ever-shifting line. There's no clear definition in the law for excessive force. It's based on the facts and circumstances of each individual encounter and whether the officer's use of force is what the law considers reasonable. So the bottom line is, if it's considered reasonable, then that's okay. If it is excessive or unreasonable or unjustified, that's not okay. But you can't look at a book and you can't get a slide rule and a calculator and figure it out. It really is based on the facts on a case-by-case evaluation. And often the difference between justified force and excessive force is in the eye of the beholder.
And that's interesting that you raise that, because it seems in the wake of these events, and certainly not just involving Mr. Floyd, but so many, there is just a popular opinion that this is excessive, this is not excessive. But to your point, it really comes down to the specific details of each specific situation. For you as an attorney, what role do those details play? What are you looking for or looking at in this conversation? And what should the public be looking for when we're assessing these different situations?
The reality is that it's hard to talk about individual cases when there's so much politics involved in the case. People want to jump to conclusions on one side or the other. Either it's always reasonable or it's always excessive. But as you know, and I'm sure your viewers know, the law doesn't work that way. It's very much a matter of the individual facts of a case. So we like to say that the facts matter. And if your viewers want to look at a situation and say, was the use of force appropriate or excessive, it starts with the fundamental principle that the police are permitted by law to use force when it's necessary. And because they're allowed to use force when necessary, they're also allowed to use deadly force when necessary. And the person who gets to decide most often if it's necessary is the officer at the time, observing what he's seeing or what she is seeing, experiencing the situation live as it happens and as it unfolds. And that is the person who who literally makes the decision on what use of force. And then it's up to the criminal justice system or the civil justice system afterwards to judge that decision by the officer. Was it appropriate? Was it excessive? And there are some starting principles that the public should be aware of that kind of get missed in the big picture of the political view on police brutality or excessive force.
Let me ask you about some of those principles. You've taught legitimate use of force for the police academy before. When you teach that class, how do you walk officers through that decision-making process?
Well, we start with what things count as force. And believe it or not, the way we teach it, just an officer showing up, just a show of authority is the first level of force. And that often resolves a lot of issues with no physical contact whatsoever. But there is a continuum of what an officer should be doing, or what options he should be considering, depending on what the circumstances around him are. And that's the thing we spend the most time on, what we call the totality of the circumstances, what the other actor is doing. Is the police officer on his own by himself, or does he have backup available? Are there third parties around that are causing the problem? Are they helping the problem, or are they making it worse? So there are literally scores, if not hundreds, of facts that a police officer at the scene should be evaluating in conjunction with the training. And part of the training is to educate them on what things they should be looking for, what they should be considering. And also a large part of the training is designed to tell them when those facts change, what you're justified in doing also changes.
So at what point, and to your point earlier, we tend to kind of just fall in these camps of it's always police brutality or it's always a legitimate use of force. In situations where you've seen it constitute police brutality, what usually is the driving factor? I mean, we hear a lot right now about systemic racism driving police brutality or acts of police brutality. Is that a factor? Or what traditionally do we see pushing that line?
The connection between systemic racism and police brutality is an odd dynamic, and when I say systemic racism, I mean a system in the way it's designed or carried out that continues or fosters or even just permits an inequality in a relationship between the parties. So it can be done on purpose, deliberately racism, or it can be just by carrying out a system that already faces an inequality and does nothing to stop it or change it. And so police brutality is a cause of that, in the sense that the lack of a positive relationship with communities, let's use like an inner city or a minority community, the poor relationship with the police also leads to police brutality because it's a two-way street. There's less respect for law enforcement by those in the community. They see it as a reflection of the fact that law enforcement has less respect for them.
Sure.
So the systemic racism leads to the point where the police feel that the community is less worthy of their time, their attention, their sympathy, or their empathy. And it's also police brutality is also a reflection of it. It's a symptom of it. So it kind of causes it, and it's also a reflection of it in the communities in which we see it.
In your experience, I mean, have there been solutions to police brutality that you've seen effective? I mean, the conversation, everyone chants, let's end police brutality. I mean, certainly this is something where anyone that you poll would say we're against police brutality. To your point, the question, is when is it an excessive versus legitimate use of force? Are there certain tools or mechanisms or certain trainings that you've seen has helped decrease the incidents?
There are, but they're hard to come by, and they're hard to train, and they're hard to maintain. But things like de-escalation tactics, which are taught but rapidly lost on the job, are some things that work. One of the areas that does work is removing police as the main contact for certain situations. So if we have a mental health situation and it's a mental health situation, right now we send 5 or 6 police officers and no social worker. Maybe it would be better if we could do it the other way around. Send a handful of social workers or crisis intervention specialists and 1 or 2 police officers. But that old phrase, when the only tool you have is a hammer, you tend to see every problem as a nail.
Right.
The tool that society in most cities use now is the police. Well, the police are not well trained to deal with mental health issues. They're not well trained to deal with mental health crises. They're not particularly well trained to deal with drug addict or drug overdose issues. So a lot of what leads to police violence against citizens is a citizen who probably needs some force, but not a lot of force, and law enforcement who's ill-equipped to handle that. Many of the claims of police violence involve people who are under the influence of controlled substance, and probably even more involve people suffering from mental health issues. So additional training in those areas is likely to help, but also additional people who are not police officers, who don't have the obligation to maintain order in society, who can then concentrate better on the underlying cause, the mental illness, the crisis the person is going through, the influence of controlled substance, things like that, without the need or without the concomitant requirement of controlling through physical force or threat of force the situation.
Sure. Gavin, let me ask you, the other thing that comes up a lot in this conversation is the principle of qualified immunity. What is it and what role does it play? There's a lot of argument right now about removing it. Where do you think that conversation goes?
Qualified immunity in layman's terms says that in this situation, a police officer cannot be sued in civil court. So qualified immunity has no application in a criminal, whether a police officer should be arrested or not. It has to do with whether you can sue a police officer for a civil wrong. And qualified immunity says that you cannot successfully sue a police officer unless the officer has committed an egregious act that violates clearly established law. In a nutshell, what that means is that the officer has to do something really bad and something that a court in his jurisdiction has previously said is really bad. So if a police officer does something really bad that no court has ever seen before, or no court has ever said, hey, that's really bad, don't do that, he probably gets qualified immunity, even if the result is tragic for the victim.
Does removing qualified immunity help reduce police brutality, or do you see this as just a non-starter in the conversation?
It's a complicated question because there is a legitimate place for qualified immunity, but it's not something that was passed by the legislature. It's created, the whole concept was created by the courts. It's been expanded by our courts, and just recently the United States Supreme Court agreed to keep it in place. But with no qualified immunity, the speculation is that police officers would be sued every day for every act that they undertook in their discretion, for minor things all the way up to major use of deadly force. And that's what we want to avoid. Essentially, you would be restricting police officers out of their own fear of being sued, or their employer or their municipality being sued over fairly minor mistakes or errors or even negligence or even things that they did wrong that they're not essentially on notice to know that are wrong. So there's a balancing. A lot of people in the argument now who talk about doing away with qualified immunity completely, I think that is well beyond the pale of the moderate conversation and the debate that should be had on qualified immunity.
Sure. The devil's in the details, as always is. Attorney Holihan, thank you for that very, very insightful conversation. Don't go away. We'll be right back. Welcome back to Face the Issues. Attorney Holihan, thank you again for being with us. This is an incredibly important conversation that we're having across the country, in communities all over the country, including in the community here in the Lehigh Valley. You recently represented a former South Whitehall Township police officer, Jonathan Roselli, and this was all over the news. It was the shooting death of a gentleman named Joseph Santos. Walk us through that case and kind of you were talking earlier about how the details are what's important in each of these situations. What were the details here? And, just walk us through that case, if you would.
Yeah, starting from this case, it happened in 2018. It's the shooting outside of Dorney Park. And on the face of it, it is a white police officer who shot and killed an unarmed Hispanic man. And you automatically have people jump into one camp or the other on whether it's right or wrong. But the reality is, as we said, the details are what's important and the facts matter. So in this case, Mr. Santos was proved to be under the influence of numerous controlled substances, some illegal, some available by prescription, but he was also acting incredibly violent and erratically leading up to the episode that led to his death. He was running through traffic on Hamilton Boulevard. He stopped several cars. He jumped on at least 2 or 3 cars. He smashed the passenger side window of a motor vehicle that had a mother, father, and 2 kids in the back of it. By the time he encountered Jonathan Roselli, he was agitated. He was not speaking any words that made any sense. He was bloodied. He made a threatening gesture to the officer. He pounded on the officer's car. When the officer told him to get to the front of the car, he literally climbed up on the hood of a police Ford Explorer, smacked the windshield. When he got off of the hood, he came around and tried to open the passenger side door of the marked police car while the officer was pointing a gun at him. So there was a lot that went into the few moments leading up to the shooting that mattered to an officer of what he's supposed to observe, what he understands to be the situation. The fact that it's the middle of the summer on Hamilton Boulevard across from Dorney Park, there were hundreds of people around, children. McDonald's is there. There are hotels. There's a bar. There's Ice Cream World. And it is true that Santos was unarmed, but that doesn't change the dynamic that Santos at that point in time created a risk of death or serious bodily injury to Officer Roselli. And the jury found, as we believed from the start, that Officer Roselli's actions in using deadly force were justified, appropriate, and legal.
How does the prosecution argue this case, or how did the prosecution argue this case coming into it?
The prosecution took a view that Officer Roselli should have done something different. And the thing that he should have done different varied depending on which person was speaking for the prosecution. So, for instance, one witness for the prosecution said Roselli should have just got into a fist fight with Santos. He should have used his fists and his elbows and his knees. Another witness said that Roselli would have been justified and appropriate using a taser or pepper spray, or if he had other things like a baton, expandable baton. So it was a little bit of little variety in what the Commonwealth put forward. But the standard for the use of deadly force in Pennsylvania and pretty much nationwide is if the person against whom the force is being used, in this case, Mr. Santos, presents an imminent risk of death or serious bodily injury at the time that the officer acts. So Mr. Santos continued to come forward to Jonathan Roselli, continued to come at him, even though he was ordered to get on the ground 5 times. He had already displayed a lack of willingness to follow the officer's directions and what appeared to be inordinate strength in smashing a car window and in essentially marauding through the traffic on Hamilton Boulevard. And in that split second, in that short period of time, the officer made a decision that if Santos was able to get to Jonathan Roselli and take his gun or hit him in the head with his own baton or tase him or pepper spray him, Mr. Santos would then have had access to a handgun with 15 rounds in it, 2 extra magazines, each with 15 rounds in it, pepper spray, a baton, a taser, a police vehicle that was still running, and inside the vehicle was a shotgun and a rifle. So, when you say that Mr. Santos was unarmed, that's true. But if he could disarm Officer Roselli, part of the testimony at the trial showed that the statistics that are compiled by the federal government on situations in which a person is able to disarm a police officer, the statistics are chilling. It said, and this came out at the trial through the expert testimony, that in every case they evaluated in which a person was able to disarm a police officer, the very next thing that happened was that that person shot or attempted to shoot the officer in every case, in every instance. So knowing that, being unarmed is a momentary thing. The ability to disarm a police officer then renders you armed, and the statistics show incredibly likely to cause death or serious bodily injury.
And you mentioned earlier too, Gavin, that this is obviously every case is different. Every case needs to be evaluated on its own merits. And we tend to have a habit in popular culture and society today to just kind of blanket everything and broad brush it. How does this, and from what you know, how does the situation involving Officer Roselli differ from the current situation involving Officer Chauvin in Minneapolis with the killing of Mr. Floyd?
The killing of George Floyd is, in my opinion, miles apart from the situation that Jonathan Roselli faced. Roselli was alone; he had no backup. It's clear that we later learned it took over a minute, maybe a minute and a half before the next backup arrived. That's a factor police officers are allowed to consider as to whether they're at risk of harm. So if there are 4 officers who can control George Floyd, he's not really a risk of harm. And what we saw on the videotapes of George Floyd murder, he's already handcuffed. He's got 2 officers holding his lower body down while Chauvin is pinning his head to the ground with a knee on his neck. George Floyd at that point is not a risk of harm to anybody. He's not going anywhere. He's not able to fight. There's just nothing observable on the videos that are available show him a risk of harm. It's also a situation that unfolded over several minutes, almost 9 minutes of just Chauvin with his knee on George Floyd's neck. With Roselli, it unfolded in seconds, and the actual shooting took place in less than 3 seconds.
Yeah, again, the details matter so much. Gavin, let me ask you this as we close this segment. With a situation like the one in Minnesota, there's a lot of conversation about the charges that are being brought up. Right now, Derek Chauvin is facing second-degree murder, and there's so many people that want to move the murder one. What are the differences in the charges, and why is that so important?
Well, right now, Chauvin, to my understanding, is charged with second-degree murder. The second-degree murder in this case involves what they allege is that he killed a person either with the intent to kill him or while committing a felony offense. In this case, the felony offense would have been assault. That a felony assault, and in the process of a felony assault, the victim died. So that's second-degree murder, similar to what we have in Pennsylvania, but it requires egregious conduct, intentional conduct that is so likely to result in the death of a person that it's not a mistake, it's not negligence, it's not an error. We don't exactly have an equivalent of that in Pennsylvania. We do have felony murder, but out in Minnesota, the second-degree murder is punishable, I believe, by 40 years is the maximum penalty for that. He's also charged with a lesser degree of homicide, third degree, which is a killing with what we would call like the reckless disregard for the likelihood of causing death or serious bodily injury. So second and third, the difference is in second, your behavior is so bad that it's equivalent to the intent to kill someone, or it is in fact the intent to kill someone. Whereas the next step down, that third degree, is you have so little regard for the person that you're dealing with, or so little regard for his life that your conduct is so bad that you essentially don't care if you end up killing a man based on the way you conducted yourself.
Sure. That's fascinating and incredibly important information. Gavin, thank you for that. Don't go away. We'll be right back. Welcome back to Face the Issues. Attorney Holihan, thank you again for your time. In closing out here in about a minute, I want to ask you to kind of just wrap this all up for us. Obviously, you work in this field. You see all the sides of these issues that we are marching about, that we're protesting about. What advice do you have to give to people in our society regarding these different cases and how we should approach them and view them?
I think there's really things to say to both sides. On the one side, the facts of an individual encounter between the police and the public, the individual facts matter, right? Not all cops are bad, but also not all incidents are good. But on the other side, systemic racism is real, right? There, in my opinion, in my experience, there's no question that our system is biased against Black and brown members of our society. So that exists. So to ignore it and say it doesn't exist really just continues the problem. And when the two sides dig in and take those absolute positions, it makes understanding or a common ground almost impossible to find.
I think these are great words of advice. Thank you so much for that. And thank you again for joining us.
My pleasure, Chen. Thank you.
That is all the time we have tonight. My thanks to Attorney Gavin Holihan for his insights on this issue. Join us again next week. My name is Sam Chen. On behalf of all of us here at Face the Issues, thank you and good night.